Um, and thank you for making space on all of your busy schedules for this special session of the Educational Forum. As you know, Title IX is vitally important topic always, and of course, but for us, especially now. And we wanted to be sure that we gave our presenter sufficient time to get through her material and to answer what I'm sure will be many questions from us. Janet Judge is the co-founder of the Education and Sports Law Group. With 30-plus years of legal experience, she advises higher ed clients and the NCAA on a range of civil rights matters, including Title IX sexual misconduct and athletic equity compliance. It is impossible to do justice to Ms. Judge's resume, but I'll offer just a few items. Since 2010, she's taught the Title IX coordinator course hosted by the National Association of College and University Attorneys. She's conducted high-profile Title IX compliance audits for private colleges, public universities, and university systems. Ms. Judge is a subject matter advisor and member of the Task Force on Sexual Violence in Sports, under the aegis of the American Medical Society for Sports Medicine. And she co-authored its position statement on sexual violence in sports. She also served on the American Bar Association's Task Force on Due Process, addressing complicated issues in sexual misconduct proceedings, and on the NCAA's Commission to Combat Sexual Violence. Ms. Judge regularly works with the NCAA's Office of Inclusion and Sports Science Institute to develop training materials related to Title IX and student well-being. We're delighted she's joining us today and eager to hear her presentation. Ms. Judge?
Thank you very much. First of all, thank you all for being here. I think it is vitally important that, from a governance standpoint, that people talk about some of the most important things that are happening on campuses. And Title IX certainly fits that bill. Today, to be clear, we're going to talk about the baselines of legal compliance. Best practices go above and beyond that, but today we're just really going to do the baseline of what your member schools are grappling with on a day-to-day basis in the implementation of regulations. And I invite you, as we go through this, to think about, as a board member, the ways that you might be keeping in touch with the sorts of things that we're talking about. And also with the understanding that what I tell you today may change tomorrow or the next day when the new rules come out. So we're talking about the rules in place right now. Those rules may change quickly, but when the new rules come out, the rules I'm talking about today will still be in place until the new rules are effective. And also to be thinking about how your students, faculty, and staff process all of the information that I'm going to be giving you as well. I promised myself when I started to practice law that I would not continue unless I was actually spending time with students on campuses and working with them from day in and day out to stay relevant. And I also have two daughters who graduated from school not too long ago, and so they are very generous with their opinions and sharing information with me about how things should be happening. So with that backdrop, this is Title IX, 37 words. As you may know, Title IX has roots in this state. Bunny Sandler, also known as Bernice Sandler, was a professor at Maryland. She was trying to get hired on a full-time basis, and when she saw some of her colleagues get these jobs and she was passed over, she went in and, as the story goes, went in and asked why that might be. And as Bunny tells it, and Bunny's no longer with us, but as Bunny has told it, she said she was told, "You come on too strong for a woman." And so she went home and talked to her husband about that last night, and apparently she says her husband said back to her, "I wonder if anybody said to any of the male applicants she'd come on too strong for a man." At that point in time, she started to do some real research and determined that there was a loophole in the civil rights laws in the education space, and Bunny Sandler was actually the person who did all the legwork to gather all the information around Title IX that was used during the hearings. So deep roots in Maryland, important roots. So no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And just to be clear, and we've had litigation around this over the years, if an institution is receiving federal financial assistance, it means all of the educational programs of that institution are subject to Title IX, not just those educational activities that are the direct recipients of that federal aid. That was an issue that was that came to light in a litigation involving Grove City, and then there was a Civil Rights Restoration Act to make that point clear, that if an educational institution receives federal financial aid, that it applies across the board. Also, when you're thinking about education activities, use a broad lens. Right? As I have said, and many of you who may be in this room or who may be online know that who have participated in athletics is that there are many educational components to athletics participation, and Title IX has recognized this since the law was passed in 1972. So that's why your educational programs, your athletics programs are also covered by this law. Today we're focusing on sexual misconduct piece of Title IX, although Title IX is a broad-based sex discrimination statute and prohibits, as you well know, discrimination in athletic equity, discrimination across all of your athletics programs above and beyond sexual harassment, including sexual assault. It's a federal law. It is a spending clause statute, meaning the federal government gives you money and in return you promise not to discriminate on the basis of sex. It also prohibits discrimination against pregnant or parenting students, and when you see the new rule come out, you will see a lot of discussion around the pregnancy piece of that as well. There was also a final rule in the employment context that was just recently published around pregnancy and employment. So you are looking at the embodiment of Title IX. On the right-hand side, that's me. I was one of the first girls to play boys baseball in the state of Maryland right when Title IX was passed. I played on a team called the Hustlers. We could talk about that at another time. But I was walked or hit every at-bat because nobody wanted to be the pitcher that the girl got the hit off of. I am a direct beneficiary of Title IX, and you can now see how long the law has been in place. On the left, sorry. Did we lose? Sorry. On the left-hand side, that's my daughter, Emily, who's about to get her PhD in math at Columbia. One of the ways that Title IX changed the academic landscape in higher education was that it directly prohibited discrimination in admissions in graduate school. And Emily is a direct beneficiary of this law, although she's pretty smart, I have to say. Sorry, we're doing, managing two different pieces here. Here are some reported experiences of incoming students. This is data collected from more than 450,000 students at more than 380 colleges and universities in the last, as of 2023, I believe. On the left-hand side, granted the type is small and I apologize, but overall, of those who participated in the survey, 14% said, answered in the affirmative when asked, has someone ever had unwanted sexual contact with you? Then you'll see differences by demographic, which I think is important for this group to consider as well. Of the LGBTQ students, 27 reported in the affirmative. Of students of color, 13% reported in the affirmative. Female identifying students, 19%, and male identifying students, as those questions were asked, 5%. In the aggregate, overall, 14%. Of those who reported that they had experienced it, the next question they asked was, did you talk to anyone about this unwanted sexual contact? And as you will see, we have varying degrees of responses in how people talked about it. And one point that I'd like to point out is the reluctance of men as compared to all other demographics to talk about this issue. And then lastly, did you file a report about the unwanted sexual contact? So 14% said they had experienced and 10% said that they had filed a report. And then remember that these are of the people who filled out the survey. Okay. A concept that I think is important for you all to think about, and all of your individual campuses are definitely thinking about it, is what's been called the red zone. This is the first few months of the academic year in the fall, where you have increased social activity, especially in the wake of COVID, where we had so much sort of isolation, and more than 50% of the sexual assaults, sexual harassment, sexual assaults are said to have occurred during this red zone activity. Just highlight that to really highlight the importance of getting information out to students as soon as possible about how to report about conduct expectations and conduct standards, and just a reminder to you about how things play out on college campuses. This was a United Educators claims report that was published in the spring of 2023, and this was talking about the roles of employees who had been accused of sexual misconduct, I was surprised by this, but 59%, faculty, athletics department 8%, student services 5%, medical roles 4%, administrators 3%, security 2%, and all other, which I imagine are general staff positions, would be 19%. Important to talk about the enforcement of Title IX, just so you know where we are. Again, I said it was a spending clause statute, right? So the government gives out federal funds and schools accept those funds and say that they're not going to discriminate. In return, as you imagine, when you break a contract, then the person who extended the money to you may want it back. So one of the ways that Title IX can be enforced is by the federal government saying, we want the money back that we gave to you because you did not honor your commitment. Title IX has been in place for more than 50 years now. That has never happened, at least to my knowledge, at any institution. But there are other ways of enforcement that don't go all the way to taking back all of the dollars extended to an institution, including student loans, by the way. Student loans fall into that financial aid piece. So the Department of Education's Office for Civil Rights is the administrative agency charged with enforcing Title IX, federal agency level. They can refer complaints to the Department of Justice for enforcement if they get to a point where they don't feel like a school is being cooperative with them. And the Department of Justice may transfer cases to OCR for investigation, although that happens less frequently, is my understanding. Now, OCR also can come in and conduct broad-based agency-instituted compliance reviews without a complaint in place. They are able to just come in and say, we're going to come and look at a particular program. And we saw a number of those happen in the last decade. There's also the opportunity for people to go to court and file individual rights of action, bring litigation on their own behalf. When they file those complaints in court, they have to have what's called legal standing, meaning they are people who have suffered injury as a result of the conduct or lack of conduct of an institution as their roles are defined under the law. And here's a little bit of a summary, right? You had prior regulations that came out during the Trump presidency, and that's how the timeline played out up on top. The final regulations were posted in May and they became effective in August. It's a pretty quick turnaround for a very comprehensive change in grievance procedure and processing of Title IX complaints. So that's what we had last time. Right now, we're waiting for the new rules to come, the new final rule to come out. Rumor has it that they may be coming out tomorrow, but I do a lot of work in sports, so I am not permitted to gamble or take any bets on that particular piece. Safe to say it will be coming out fairly soon, and safe to say there will be some significant changes which will require policy changes for schools and different ways to think about likely who will be required to report, the kinds of training that schools may be needing to do, and certainly what your policies may say. Little quick look at the rulemaking process, just because I'm interested in it as I go along this route. Right, the rules were initially put out there for public review. There was plenty of opportunity for people to review the rules and then write in what they thought about them, challenges that they had. Many of the higher education groups wrote very thoughtful responses to the Department of Education. In the federal rulemaking process, there is a requirement that the Department of Education looks through all of those comments and then they offer some response. That's why you typically have very, very long preambles to the rules that will eventually come out. Right now on the right-hand side with the box, that's where we are. We're waiting for the final rule to be published. Everything else has been met to this point on the final rule. So for now, we're worried about the rules in place, which are the 2020 regulations, and that's what we're going to be talking about today, and happy to answer any questions on those. Anything that you ask me about rules that will be coming out, I'm just going to make up as I go along because I don't know. Okay, some very baselines. Schools are required to designate a Title IX coordinator and provide notification of the contact information of that person. They have to notify a broad group, applicants for admission and employment, students, employees, and all unions or professional organizations holding collective bargaining or professional agreements with the school. They have to know how to be able to contact your Title IX coordinator. We are increasingly coming to a place where that is very much a full-time job, including additional people to help you do that full-time job. So have your Title IX coordinator be in other duties as assigned is just not practical at this point in time, as you'll see as we go along. Schools are required to have a non-discrimination policy with certain required content, and they're required to publish that. Now, I'm not going to read every slide. We'll be here all day. This is for you to have and look at your leisure, but there are all kinds of required components. But you may see in some agreements that schools may have with the government additional components. For example, some of the cases I reviewed now require very specific information about pregnant and parenting students in that non-discrimination policy and other things that aren't specifically included in the regulations. So you may have, when you have individual back and forth with the government over a particular case, they may require you through contract to do things above and beyond, or you may agree through contract to do things above and beyond what the laws require as a baseline. They also require you to have updated information on your school websites and any publications that are out there, including, admissions publications and other things around this information. So it's important to make sure that that's all out there as well. You also cannot use or distribute a publication stating that the school treats applicants, students, or employees differently on the basis of sex unless the treatment is permitted by Title IX. For example, you're allowed to have gender-based differences in athletics. The law requires you also to adopt grievance procedures And a lot of what we'll talk about as we go through is just giving you a little bit of a glimpse about how these grievance procedures play out. So you have to adopt and publish the procedures. They have to be in alignment with the rules that are set forth in the regulations. And you have to give notice of the school's grievance processes and procedures as well. You have to make sure people know how to file a report or a complaint of sexual harassment, how to file a formal complaint, and we'll explain why that's different, and how the school will respond. So here's the scope of institutional responsibility, and we'll talk about each of these. But a school is required to respond promptly and effectively in a matter that's not deliberately indifferent. Deliberately indifferent is the legal standard under Title IX that applies to schools. So a school has to respond when it has actual knowledge, that's a legal term that we'll talk about, of sexual harassment, another term that has a lot of definitions, occurring within the school's education program or activity, another thing that is defined, against a person in the United States. I think we're good on that one, although I do get the question of what if you're in the air and something happens, you get a text or something else. Also questions about, are we really saying that if we have an educational program that's happening outside the United States and something happens, that would not be covered under the current rules, right? If it's happening against a person outside the United States, it actually is not covered under Title IX, although you are permitted to have more broad-based policies that would address that particular behavior. Yep.
Even if it's a U.S. citizen?
Mm-hmm.
Well, I didn't hear the question.
She said even if that's a U.S. citizen abroad, yes, because the law itself says against a person in the United States. Right. So what is actual knowledge? This was in the 2020 regulations. Actual knowledge means that certain people at your institution know about an allegation. The Title IX coordinator, either because somebody's come and told them about something, or they've seen something or heard something, or any official at the school with authority to institute corrective measures, right? Unless that person is the person accused, that does not put that school on notice, right? If the person who knows about it is the person who's doing it. Now, that's a sort of a narrower set of mandatory reporters than we had in the last set of regulations, and likely a narrower set than we'll have in the next set of regulations. Schools, of course, may always adopt a broader definition of mandatory reporter, and many schools across the country have, to encourage reporting and response, but know that a school's Title IX obligation under the law is only triggered if those people that I talked about, officials, right, who have the power to implement corrective measures know, or the Title IX coordinator, right? So it's a legal concept. Incoming students, this is back again to that data collection set that I was talking about earlier. We find that students often talk to their friends and family, right? So getting the information to them about who they can go to and why they should go to that person and how you can build trust is an important piece of your overall Title IX program. Not surprisingly, the vast majority of students report that they go to their friends or their roommate, followed closely by family members. Crisis centers, not at my school, right? So it's showing that they're sort of worried about people knowing about what's going on with them. Campus or local, police, security, administrators, faculty, staff, and then crisis centers at my school. So very, very interesting. I think if you had another slide that talked about in the athletics context, where I also spend a good amount of time, you also find a general reluctance to be reporting within athletics because people are concerned about whether or not people within athletics will be looking at them from there on out through that lens rather than the lens of them as a talented student athlete. Confidential resources is an interesting piece, and it's a hot topic of discussion, and one that I've certainly had a lot of discussion with schools across the country around. The regulations allow you, first, confidential resources in the first instance are those people who have confidentiality given to them by their licensure, right? So doctors or religious folks or others. And only when they're operating in that role, right? So the licensure only applies, the confidentiality protections only apply when they're operating in that role. So think about a team doctor who may be out at a social gathering and not doing team doctoring, and here's some, it's, that likely the confidentiality would not apply. But the regulations also allow schools to designate people who don't have confidentiality by licensure. Now, there's competing provisions here. You have some students say, there are people on campus that I would like to go to who I trust. And if you don't give them the confidentiality, I'm not going to go to them. So you don't want to have a barrier to reporting, you want to open the door. On the other hand, a school giving confidentiality doesn't hold up in litigation. So you may, that's not a privilege that would hold up in a court of law. So you may run into instances where students come and share information and believe it's in a confidential context, and then later are found that they can't keep that confidentiality going. So schools struggle with the confidentiality piece, and it's something that will continue to be something that people think about. So what is prohibited conduct? Well, we have sexual harassment, and sexual harassment is a very broad-based term. It also includes sexual assault and sexual violence. But on the sexual harassment side, we have quid pro quo. That's where somebody conditions, right, a promotion or something else on some sort of sexual relationship or romantic type activity. Right? I'm going to grade your test tonight, but I'd much rather maybe go out to dinner with you tonight and talk to you. You get it right away. They're the two things that are acting in concert. They have control over your grade, but are also asking you to do something. Hostile environment, I imagine most of you in this room believe that you have been subjected to some sort of a hostile environment in your lifetime. In the sexual misconduct context, it's unwelcome conduct, right, that a reasonable person determines to be so severe, pervasive, and objectively offensive that effectively denies them equal access to their education program or activity. A lot in there to unpack. We'll talk about it in a second. And then we have this catch-all sexual assault, which includes dating violence, domestic violence, and stalking. And we'll talk about those definitions, but you have a lot of definitions happening. So you think about it through the eyes of a student or the eyes of faculty and staff. So the quid pro quo, right, requiring submission, sexual or romantic conduct made either explicitly or implicitly a term or condition of an individual's academic or employment success. That's where we have power differentials come into play. Important to think about this. And where we have this at play, you have strict liability that may attach, where somebody who has power over another person is conditioning some sort of inappropriate behavior in order to maintain their job. Hostile environment, I said the unwelcome conduct has a purpose or effect of substantially interfering with your work, performance, your education, or creating an intimidating, hostile, or offensive living, learning, or work experience. Now, the behavior must be severe and pervasive. That's a fairly high standard. It also has to be subjectively offensive. So if it happened to me, I would have to be offended. And then I also would have to show that the reasonable person, not like me or unlike me, also would be offended, right? So it does impose a reasonableness standard, but it's the reasonable person standing in my shoes. As you might see, this applies also in all other formats of discrimination too, discrimination on the basis of race, national origin, other components. Sexual assault, having or attempting to have non-consensual sexual intercourse or sexual contact with another individual, again, no consent. It's a broad term and could include the touching of various body parts, includes behaviors like rape, fondling, and incest. The lack of consent includes situations involving the use of threat or force or coercion, or where an individual is incapacitated. So you may have situations where you have drugs or alcohol involved. You can have situations where people have conditions where they're incapacitated as well. Sexual assault may but does not require penetration. It can be just touching of certain body parts of another person without consent. That's also sexual assault. Now, there's a lot here, so I'm not going to go through all of this, but consent, as you might imagine, is a pretty important component when you think about Title IX sexual misconduct generally. And it's not defined by the Title IX regulations. Typically, you think about it as affirmative, voluntary, mutual agreement to have sexual contact. In the sexual assault context, typically consent is defined by your state laws, right? So you would look and see what those say. In the sexual misconduct, in the harassment component, that was back talking about unwelcomeness, right? Not welcome. So there was some discussion when Title IX sexual harassment training started years and years ago about what unwelcomeness meant. Did it mean that if somebody started telling a joke that was problematic or making comments that were problematic, and somebody stood by and didn't say anything and was just silent, was there an obligation on that person who's standing there to actually say, oh no, I object, to be able to say it was unwelcome? No, silence can still indicate unwelcomeness. It's the conduct that you're looked at, right? And if you want to say, well, it was welcome, you'd have to show much more from somebody who was standing there. Consent can never be given by somebody who's under the statutory age of consent. There are people in the room, I imagine, who know Maryland law much better than I do right now, although I'll get up to speed. But in Maryland, my understanding is it means under the age of 16, or when there is a 4-year age difference between the parties under that age, or when somebody's asleep, unconscious, or incapacitated due to drugs or alcohol. And don't forget, there are always power and control issues specific to athletics as well, that are things that are always in place around people who may feel isolated and feel very dependent on others in order to continue their educational experience at an institution. So these are the ones, if I was going to really be not a good but nice presenter to you, I'd do a pop quiz and ask you all to define dating violence and domestic violence. I mean, define dating for me right now, right? Violence committed by a person who is in or has been in a romantic or intimate relationship with the victim includes but not limited to sexual or physical abuse and or the threat of such abuse. It does not include acts covered under the definition of domestic violence, and we're going to get to that right now. So here's domestic violence, committed by a current or former spouse or intimate partner of the victim or someone similarly situated. Committed by a person with whom the victim shares a child in common, or committed by any other person against an adult or youth victim who is protected from that person's acts under the domestic or family violence laws of the location in which the crime of violence occurred. So you're a student, and you just got all those definitions. How are you doing? How are you doing, right? So the challenge of institutions is taking all of this very legal information and sort of boiling it down into what this actually means for people in the training. And stalking was something that, was surprising to me in some of the work I've done about the vast majority, the amounts of stalking that has gone on, because it was one of the most underreported areas of misconduct, I think, when I was doing some of the work at another system. It's a course of conduct directed at a specific person that would cause a reasonable person to fear for their safety or fear for the safety of others, for example, their family members, right, or people who they're close to, or suffer substantial emotional distress, right? So this is a very broad term with very real consequences for the person who's being stalked. And it can happen in the cyber context, cyber stalking, right? And other forms of unwelcome contact with another person. So you can just have somebody who doesn't even come out of a room for days who is actually in the midst of being stalked from cyberspace. It may involve individuals who know each other, and it may involve individuals who have never met. So stalking is a really difficult one, and it's very important to get this language out, because once you get the training out around stalking, you will see the complaints will increase, which is not a bad thing. It means you're getting the message out, so be clear. For the visual learners in the audience, I just like to have this. So you have that, the big circle is Title IX sexual harassment, which also includes sexual assault. But then you have that interpersonal violence and stalking. Some of it has sexual components, and some of it is not. It's just violence that is not sexually related, but is in the mix because of a relationship. And then, as you, I'm sure, see, because you follow the news for sure, hazing is in the news. And many hazing cases, as we have seen, and by the way, there are many hazing cases out there, some reported in the news, some not. Many of them have components of sexual violence or sexual harassment in them as well. And it's important not to say, oh, that's hazing and we'll just deal with it as hazing, but to understand if it has the Title IX components in it, you need to bring it in and deal with it as Title IX prohibited misconduct. Also, Title IX also applies to employees, right? So schools are sort of trying to balance obligations they have under Title VII, which many of you who are involved in private business who may be in the room today are thinking about when you think about sex discrimination in the employment context, you're thinking about Title VII. And so they're trying to balance, you still are obligated to address Title VII, but now you have Title IX as well, which applies in the employment context. And it has a little bit of tweaking about different definitions, which your Title IX folks are really working to make sure that they've got in hand. So just don't need to get into the weeds on that, but just another reminder, your HR folks have to work with your Title IX folks, right? And there are a lot of different ways that this all overlaps. So what is a program or activity? You think that's pretty clear, but there's a lot of case law around this. This has been challenged in a lot of the court cases that are out there. Locations, events, or circumstances over which the recipient exercised substantial control over both the person who is accused and the context in which the sexual harassment occurred. Let me give you one example. There was a dating violence case that happened off campus. The allegation was that the individual who lived in the off-campus house would not have been allowed to live there unless the coach approved the campus location, even though the school didn't own the house, right? There was a requirement that the coach approved. And the student was paying for the rent for this with the scholarship that the school was providing. But still, the school did not own the premises. The court said, well, that raises questions for us around, whether or not they exercise substantial control. But they said, the school did not have any control over the context in which the sexual harassment occurred. So that case did not move forward. But that's just to give you an understanding of all the kinds of things. As you might well think, sorority and fraternity houses, other houses that may be off campus used by your student organizations, are they yours or are they not? And those are the kinds of cases that we see. Includes any building owned or controlled by a student organization that is officially recognized by the school. As you can see, that can be quite broad as well, right? So somebody's signing the lease. Are they signing the lease as the president of your organization? Or are they just doing this in their own personal capacity? So those are all important things to happen because, as you might well imagine, activities happen at these places. And so it's important to get a good understanding. Again, this is Title IX. You may have other policies, procedures, or the Clery Act may come in that may extend your jurisdiction to some of these places as well. So what are the reasonable takeaways? The bright line rule is that the official recognition of a student organization brings buildings owned or controlled by the organization under the auspices of the college and university and within the scope of Title IX. So as part of a process for official recognition, for example, a best practice might be that a school would require a student organization that owns or controls a building to abide by the Title IX rules of the school. Here's that person in the United States. The regulations limit Title IX coverage to discrimination that occurs against a person in the United States. Title VII, on the other hand, applies to U.S. citizens working for the U.S. corporations abroad. And Clery Act applies to students and employees regardless of location. So I'm just talking about the Title IX context here. All right, so where's the liability standard? It's deliberate indifference. And what does that mean? And you know, there's been so much litigation on it, alleging all kinds of things, but basically saying the school's not following the regs, right? The school is not doing what it's supposed to do, either because the policy it has in place doesn't abide by the regulations, doesn't meet the regulation standards, or you have an awesome policy in place, but you just don't follow it, right? So those are the deliberate indifference sorts of standards that you're looking at. You're deliberately indifferent only if your response to sexual harassment is clearly unreasonable in light of the known circumstances. Parties need to be treated equitably, or else you'll have those sorts of complaints that may be brought, right? Deliberate indifference because you have a gender bias in how you evaluate Title IX complaints. You have to follow the school's procedures that comply with the regulatory. We talked about that before you impose any disciplinary measures. That was a new piece of that 2020 regulations, and we may see some easing of that with the new regs, but we will wait and see. Other than emergency removals, which I'll talk about. Well, this last one is important. It's written in legalese, but it's an important piece, right? The regulations state that the Assistant Secretary, so the Department of Education, will not find deliberate indifference just because they would have made a different decision given the same facts, right? So there is still some deference that is given to schools. So when you're talking about prompt and effective institutional response, which is what your obligation is, you have to assess, right? When you hear something that's going on, you have to do an assessment. You have to contact the complainant. You have to offer supportive measures. You have to explain the formal complaint process. And you have to make sure that you provide compliant grievance procedures and process. And I'm not going to let you get away with it, and then we're going to talk about all that. A complainant is an individual who's alleged to be the victim of conduct, even though they may not be the person who complains, right? But when we're talking about complainant, it's the person who is alleged to be the victim, and the respondent is the person who is alleged to have committed the act. Right? So Title IX coordinator is the one who is responsible for making sure they reach out to whoever the complaint is to discuss and consider their wishes regarding supportive measures. For example, do we need to separate people? Do we need to provide some academic accommodations? Do we need to think about how you are accessing your educational program or activity? Can we make some accommodations to make sure that everyone involved in this continues to access education, but we do without doing harm? You have to explain supportive measures are available with or without a formal complaint. So somebody can come in and not even trigger the evaluation process, but still ask for support, and the regulations say that you will be given support. Or you need to actually, they don't need to come in and ask, you need to tell them that they have the right to get support. And you have to explain the process for filing a formal complaint at that time. Supportive measures are defined quite broadly, right? They're available to the complainant and the respondent equitably. I talked about last slide about the complainant. That's because respondent doesn't even know something's going on, right? There's no complaint being in place. But if there is a formal complaint and someone is named as a respondent, then supportive measures must be made available to both equitably. They're non-disciplinary and non-punitive, right? Counseling, course-related adjustments, modifications of scheduling, campus escort services, mutual restrictions on contact between the parties, changes in worker housing. You can imagine how many ways your faculty may be interacting with Title IX if they have two students in the same class, or club programs where people are working out together, or a variety of other ways. So it requires a lot of interaction across campuses. They must be designed to restore or preserve equal access to the education program. And if a school decides not to give them, or something that's been requested of them they believe is just not something that's required, they have to document those reasons and keep that in case the Department of Education or the Department of Justice comes knocking, so you can explain why a particular supportive measure may not have been provided at a particular time. Okay, the grievance process is not triggered unless there is a formal complaint. So what is a formal complaint, right? And this may change, but right now, they must be filed in person or any other way that they get to the place they need to get to by a complainant to the Title IX coordinator, or they must be signed by the complainant in some way or some facsimile of a signature. Or if you have a reluctant complainant, but the Title IX coordinator believes that they've heard enough that they believe something should be investigated, the Title IX coordinator can sign the complaint. It has to allege sexual harassment, and it has to request an investigation, but those are, if somebody forgets, if a student doesn't put that in, I would say the school should make sure that they provide some guidance there. This is something that sometimes is surprising to people. Title IX is only about individuals. So if you have an organization that's been accused of sexual misconduct, say a hazing case or something else, Title IX doesn't get into organizations. Title IX is just about individuals, so you have to make sure that you have separate policies and procedures to deal with organizational behavior and how you might treat the organization moving forward. Yep. Yes, sir.
Thought just occurred to me, and I'm sorry to interrupt, but this question pertains to what we're talking about. In my early years, I was a prosecutor in Montgomery County, and I tried every kind of sex case there is. And one of the things that we always ran into was the victim being reluctant, not wanting to be subject to being asked questions publicly in a courtroom, being cross-examined. And so my question is, what happens when a school has knowledge of an offense like that? And it's been reported, but the student says, I don't want to go through that. I don't want to have anything to do with that. What does the school do in a situation like that?
It's a great question, and for somebody with a lot of experience behind it. That's why the provision was placed in there that the Title IX coordinator could sign, but that doesn't get at the difficulty of moving forward. And it was, it has been identified by many Title IX coordinators and schools across the country of the very real difficulty of pursuing a Title IX investigation where there may be some very troubling behavior where there's not cooperation of the complainant as that's defined, even if they don't agree to be identified or participate in the process.
But what
The law says you cannot require a complainant to participate if they don't want to participate. So the school tries to do whatever they can using the Title IX coordinator's complaint to move forward. So they will still do the investigation. They will still have a hearing. If it, do the investigation, if it moves forward and they believe there's information that would move it forward to a hearing, you still do the hearing, and then at the end of the day, the hearing officer can only decide what's been placed in front of them.
Do you want to take another question?
Please.
There was an article in the Washington Post this morning, and I'd seen it on the news over the last couple of days, over the case in West Virginia, where West Virginia passed a law in 2021 or 22 regarding transgender biological males competing in female sports. A 13-year-old girl in, I guess, junior high school or middle school filed an action because he is a biological male, apparently been taking puberty blockers since she was 9 or 10, which kind of hard to believe, but anyway, that's. But she wanted to be on the girls' team. Took it to court. The lower court said no. They upheld the West Virginia law that said you couldn't have transgender students under Title IX. She took it to the Fourth Circuit. I think it's the Fourth Circuit, which made that their decision earlier this week, which said under Title IX. The female athlete, or claimed to be a female, biological male, had under Title IX had the right to compete with girls, even though she's a biological male. This is still never been decided by the NCAA at college level, but it was decided by the NIAI.
Yes.
About last month, which said biological males of their birth gender could not compete in college female athletics. So all this is based on the decision was based on Title IX. I thought you'd get to this somewhere in this presentation because it's one of the largest topics that surrounds Title IX in America today.
So the presentation today is on Title IX sexual misconduct, and that's Title IX athletic equity. So it's not within the purview of my presentation.
This was athletic, and it was school related because it was her school. It wasn't a
It's about athletics participation, which is athletic equity, which is a different part of Title IX. This is about sexual harassment, including sexual misconduct. I'm happy to talk to you about it after this presentation, but trans athlete participation is not part of what this presentation is about
So
today.
you're not going to talk about it today, or
I'm not talking about trans athlete participation. That's not what my charge was. It was to talk about Title IX and sexual misconduct, but I'm more than happy to talk to you about it after the presentation if you'd like.
Okay. Thank you very much. Sorry, I lost your train of thought.
No, that's fine. I would say in the, at the NCAA level, we're talking about a grand total of 10 athletes. In the school grievance process and procedures and requirements, here's what we need to remember around grievance requirements under Title IX. Required to treat parties equitably. Remedies must be designed to restore or preserve equitable access. So the remedies are not set forth in the Title IX regulations, but it's a good reminder there that we're always talking about education, so the remedies are expected to restore educational access. Requires objective evaluation of all the relevant information, provides for the credibility determination. Schools are allowed to weigh evidence before them, but they must do so equitably. It requires that Title IX personnel and those involved in the resolution of a complaint are trained and also are trained to recognize conflicts of interest and bias and to take themselves out of the mix if they're found to have or they believe they have those conflicts of interest or bias. There's always a presumption that the respondent is not responsible absent a determination of responsibility after the grievance process has completed. The grievance procedures must include reasonably prompt timeframes for process, appeals, informal resolution. If you have that, limited good cause delays are permitted, provided you provide notice to the parties. For example, if the local law enforcement came back and said to you, we have a concurrent case going on and we need you to hold for a couple of minutes so you don't, or a couple of days so you don't interfere, but that's always evaluated under a reasonableness standard. Could also be good cause delays, could also be because the parties are not available or the parties' advisors are not available, but again, within reason. You're supposed to set forth in your policies a range of possible discipline and remedies where responsibility may be found. You also have to decide on the standard of evidence, right? So in the currently, it's either the preponderance of the evidence standard or clear and convincing standard. Now, one thing the 2020 regulations came forward and said is, you can't have one standard for your students and another standard for your employees when it comes to Title IX cases. We typically, and you probably have under faculty agreements or union contracts or others, set a standard. So that became a very difficult point to address because typically the standard that applied to faculty was higher than the more likely the not standard that many schools had put into their policies and procedures under Title IX. But in any event, you can have either standard, it just has to apply across the board. There are appeal standards that are set forth in the rules, including the procedures, the timelines, and the basis for an appeal, and describing the range of supportive measures available for the parties we talked about. Now, this last one is important. sorry, I'm actually not multitasking well. I apologize for that. Not required, you can't require, allow, or rely upon, or otherwise use questions or evidence that constitutes or seeks disclosure of information protected under a legally recognized privilege unless that privilege is waived by the person holding it. This happened because some schools had been able to access counseling records of their students without the students giving permission, so they made sure that they put this provision in the regulations as well. Sorry for the... Okay, so that's what you need in your grievance procedure, so you can see, but you also can add more things if you want to, just to, keep the complicated piece of it out there. But when there is a formal notice, right, or formal complaint, then you have to have a written notice of allegations to the parties who are known. And in that, just so everybody knows, people are given good notice. They're told what the allegations were. They're given names, times, locations, with sufficient time to be able to prepare for any interview that you may have to participate in. If you have a provision in your code that says some people who provide knowingly false statements in these sorts of proceedings will be disciplined, you have to put that provision in that notice as well. Okay? And this notice goes out to both the complainant and the respondent. People are also permitted to have equal opportunity to have an advisor of choice. So let's just talk about that for a second, because I think there's some misinformation around that. The individual gets to come with an advisor. It can be their friend. Sorry, it can be their friend. It can be their parent. It can be their lawyer. It can be their parent who is their lawyer. They are allowed to have that person. What if one party has a lawyer, but the other party doesn't and asks an institution for an advisor? Must the school give that other party an advisor who is a lawyer? No. The regs say there's nothing built into it that says that they have to evaluate the sufficiency of the advisor or the quality or experience of the advisor. There's just an obligation on the institution to ensure that both complainants and respondents have advisors of their choice at these proceedings. Schools are allowed to put in place rules of decorum for those advisors as they get involved in the process. As you might imagine, and I'm sure you know this better than most of us, the school process is very different than the courtroom process. And the rules that are in play and the kind of evidence that may come in and all that is much broader actually in the school context than would happen in a court of law. Sometimes lawyers come in very much having been in the court context and sort of bring that perspective when they come into school proceedings. But the regs say very clearly schools are allowed to set the guidelines around what happens. Okay. Emergency removals, is important to talk about this. I think this is an important piece that I'd want to think about, and it's something that schools have been evaluating since the regs were put in place. So a school can remove someone who is accused from an education program or activity on an emergency basis, provided these very limited steps are met. They conduct an individualized safety and risk analysis. They determine that the person who has been accused poses an immediate, imminent threat to the physical health or safety of anyone that would justify removal. So it's not whether or not there is an emotional or mental component here. It's physical health or safety. Very, very specific language. Determines that the threat arises from the allegations that are at issue here, the sexual harassment or sexual assault. And then you provide that person with an opportunity to challenge those removal decisions immediately after. Right? So think about that context. You can imagine there are many times where you get an emergency situation, you find out that there's been an allegation, there may be a big event the next day that person may be participating in, it's hit the news, you have a complainant who's quite worried, you have all kinds of things going on, and what are the school's obligations in that particular space? You have to get together very quickly and do this sort of an analysis to determine what's happened. There's been some litigation brought around this, as you might imagine. It was brought in the athletics context again, where there was a student athlete who was accused of off-campus sexual assault, and the athletics department suspended that student athlete from athletics participation, which, with the advent of NIL, name, image, and likeness, and that student had a lot of opportunities for that, presented all kinds of harm that we haven't seen in athletics to date, right? We're in a different sort of world here. The court went through that, and again, remember, substantial control over the person and the context in which it occurs. It was an off-campus situation, so the school had a different policy or procedure. The athletics department had their own policies and procedures around the suspension of a student athlete involved who had been arrested for a crime of this nature, and so the court said we're going to sort of get out of the way of that. Yes, please.
Is there a provision, once a complaint is filed, is there a provision where either the victim or the accused or the school can ask for confidentiality? For example, if it's being investigated, but it isn't confirmed that it's actually happened, or if you have a reluctant victim like we were talking about who wants to cooperate but wants to do so privately, are there provisions to protect under that situation?
I'm smiling here because I'm trying to figure out how I get to bring you to all of my presentations moving forward so you can ask the good questions. The regulations actually say that you cannot prohibit a complainant or respondent from talking about the case, or the allegations. It's quite clear.
That's good to know.
And that has come up in certain cases that we've read about fairly publicly. And so the question was raised by schools. Can you say you can't talk about it? And with advent of social media too, it's not just it's talking about it in very, very public ways. All right, rules around dismissals of formal complaints. So when will a school potentially dismiss? You have to dismiss a complaint if taking all the allegations as true. Even then, it would not constitute sexual harassment, including sexual assault, as that's defined, either because the conduct doesn't rise to that level, or you don't have a person who's engaged, who is a covered, a student who's involved in your education program or activities, right? Or it didn't occur in the school's education program or activity, or didn't occur against a person in the United States, right? No, you have to dismiss it. Have to dismiss it. Although you may have another policy or procedure that covers that activity, but it cannot be, it's not a Title IX case. It's a permissive dismissal. If the complaint notifies the Title IX coordinator in writing that they want to withdraw the entire complaint or any of the allegations. So school's going to make a decision in that point. Either we will dismiss it, or because the school independently has an obligation, right, to respond to conduct that violates Title IX, they may decide they have to move forward, or they wish to move forward. The respondent is no longer enrolled or employed at the school, right? So this is something where that's a permissive, so schools have debated when somebody leaves in the middle of an investigation, are we going to continue to work through that investigation until the end? Or are we just going to say, oh, they're gone, we're done? And as you know, there's been a lot of discussion in the news about people who go from school to school to school in those situations without having these sorts of things. The NCAA has tried to address this by actually requiring students who are transferring to say whether or not they have been subject to a Title IX investigation at their prior institution.
A little bit to me, would not constitute sexual harassment even if proved. In other words, if it's proved that it's sexual harassment, it can be mandatorily dismissed?
No, it would not constitute. So if I come to you and I make an allegation, and you evaluate the allegation and say it doesn't fit any of those definitions I gave you at the beginning, then you have to dismiss it, right?
So-
But if it's still problematic behavior, it just it wasn't sexual-based behavior, you may be evaluating under your code of conduct or something else.
Yeah, the words were just confusing, but I understand.
Yep. Or specific circumstances prevent the gathering of evidence sufficient to reach a determination. Right? That would be a very specific circumstance. So if something is dismissed, what happens then, right? So it hasn't gone to the end result. You provide written notice of dismissal and reasons to both parties, and you provide an appeal process at that time. So appeals can happen from dismissals as well as final findings of responsibility or non-responsibility. And then, as I just said, it can still go on in under another policy or code, providing your policies are well written and provide for that, right? It's important. This is where you really want to tighten up your policies and procedures and look at what they say around that. As the Department of Education said, nothing in this final regulation prevents a school from addressing conduct that is outside of its jurisdiction. Schools are not required to provide informal resolution of complaints, right? Restorative justice, mediation, all sorts of different things that are out there and that are gaining traction in this field for people who believe that they are doing good things out there. You cannot have informal resolution without a formal complaint, however. So if something comes in and you say, hey, why don't we just go and have a mediation out here. You don't need to file a formal complaint. That's not how it works. The regulations require a formal complaint to be filed in order to get to the informal resolution process. Again, schools are not required to offer informal resolution for anyone. And it may not be offered in cases where an employee is harassing a student. Alleged that an employee is harassing a student.
That Maryland law prohibits us from addressing sexual assault cases under an informal process.
And Maryland law prohibits you from addressing sexual assault cases.
It's important for this group to know that.
Anytime, jump in. I have everybody here. It's great. Wonderful participation. It requires an additional written notice so everybody really knows what's going on, right? What are the rules around informal resolution? Because you may be interacting with each other in a much different way. Written notice again about the allegations, so you keep the focus on what is at stake, what the process is as the school has defined it, your right to withdraw either party at any time prior to agreeing to a resolution. And then this last one is important, and related consequences associated with participating, including whether there will be records of what you say back and forth, right, and how that goes, right? So schools are trying to figure out how are we putting these informal resolution processes together and how will they play out. So, okay, now say they've said we're not going the informal resolution, there's a formal complaint and the investigation of the formal complaint. You're going to hear this from me again and again and again. You treat the parties equitably because that's a very important thing. The school has the burden of proof and evidence gathering. There was some concern that schools were sort of putting it on the students to decide to gather the evidence and do all the work. And they said, no, that's not what this is all about. They've come and they can share with you, they can give you information, but it's not their burden to go and do all of that. There's a very broad evidentiary standard that it says the rules of evidence don't apply, but then they don't really define it, but they do define what can't come in, and it's very, very narrow. So that means it's pretty broad, provided it's relevant, right? And notice to parties and advisors of all meetings with sufficient time to prepare. So you give them an understanding of who will be there, the purpose of the meeting, so they get plenty of time to put it all together. And as you can imagine, deliberate indifference is when you don't do this stuff, right? There's cases out there that says I was given 24 hours before a hearing, and that was the first thing, right? That's deliberate indifference, those sorts of things. And then both parties get the opportunity to inspect evidence and provide written response before the investigative report is completed. They get 10 days to sit with it and provide information before that investigation report is completed. Again, the school has the burden, I said, provide equal opportunity to have advisors, present witnesses, freedom to gather and present relevant evidence. The parties may discuss the allegations, so I had that in there just waiting for you. Written notice of date, time, and location of all the interviews. Both parties also get to look at all of the evidence that's out there, too. The investigative report has to fairly summarize the relevant evidence to be provided to the parties and their advisors at least 10 days prior to a hearing for their review and response. Just for the most part, investigators, they're just finding the fact, right? They're weighing evidence. They're saying why they believe somebody was more convincing than another. There can be all those sorts of things in there, but typically they're not the decision makers. They're not the deciders, right? So they're getting the investigation report together to provide to the hearing officers. So then that's the hearings next, the adjudicative process. Again, fair process, treat parties equitably. This is the biggest controversy about these rules, was probably the cross-examination piece. It has to be a live hearing in the college and university context, although technology can allow people to be in different places, but it has to be happening at the same time, and people have to have the ability to see the other party, right? Important. It also allows for live cross-examination, which was a big discussion point. Would this sort of chill people's willingness to bring complaints forward? The cross-examination may not be done by the parties, but is done by their advisors, so that gives you a good idea of why the advisors are so important. If somebody shows up for a hearing and doesn't have an advisor, you have to give them an advisor. Likely, you should give them an advisor and give them some time to walk back and think about it. But anyway, they need to have an advisor or they won't be able to ask the questions necessary.
A while ago that the school had no responsibility to provide an advisor?
Of equitable quality. I take that back. Of equitable, if somebody has a lawyer, they have no responsibility to provide somebody with a lawyer. They have a responsibility to make sure they have an advisor. They just don't have to be of the same education level or the same experience in these cases. Right? So you can't have a hearing unless you have an advisor because you can't ask the questions that you need to ask. You can use technology. The hearings are recorded and you have to retain them. You have to do relevancy determinations in real time. This is interesting. So this is even different from court proceedings, right? So in court proceedings, people ask questions, and then you all watch these shows. People pop up and say, "I object." In this case, after every question, the hearing officer has to decide whether it's going to be allowed and whether it's relevant, right? Whether or not anybody has an objection about it. So the person who's there dealing with this has to really be on it, right? It has to be figuring out what's going on. We have seen some retired judges coming in as hearing officers, lawyers, and also very, very dedicated and well-trained faculty, staff, and people on campus. Again, fair process, just because I'm just going to keep on reminding you all. Relevant evidence. So let's just talk about that. Relevancy just refers to a fact, witness, or other piece of information that a reasonable person could conclude makes a material fact more or less likely to be true, right? There's a lot of discussion in the court cases that come out about whether or not evidence was allowed in or not allowed in, and whether or not schools were being inappropriate by saying we're not going to have 20 people come in and talk about what a good person you are, right? We may say that that's repetitive and we're going to sort of cut it off at one point. You can't have questions and evidence about the complainant's sexual predisposition or prior sexual behavior, generally, unless the questions concern whether or not consent had been given in that particular instance. Relevance is broadly defined, but again, the hearing panel officer will decide if the evidence is relevant, and then the hearing panel will decide what sort of weight to assign to the evidence or credibility. Again, we said schools may use either the preponderance of the evidence or the clear convincing standards. So if you have staff who are your hearing officers, right, you're teaching them a lot when they're trying to figure out how to serve and what this all means. You can, outside cases, so for example, some people say, well, that person was never charged by the police or criminally, right? They weren't arrested. The police don't charge. They weren't arrested and they weren't charged. Or there was a criminal case and it was dismissed, so how come your case hasn't been dismissed, right? They're different standards, right? Different processes. So just because something may have been dismissed or not charged in the first place doesn't mean that the school can rely on that and say, we're not moving forward. Yeah.
You just said this thing that I've been wondering about. I'm not a lawyer. So what I've been trying to do is test the things you're saying there as though I were a lawyer. So could you just, maybe now or at the end, explain in what ways, like, so for example, the first one there jumps out at me. In what ways is this process different than what someone accused would get or go through if he or she were just in a criminal case? So for example, that first one, preponderance of evidence, I think that's a lower standard than what a court case would be, but now I'm wondering what else on there is different than a court case.
Right, the rules of evidence don't apply. This forum is supposed to be an education forum, right? It is an education experience. It's part of the college experience, right? So the forum is quite different. The questioning, and there's no objections in formal, right, the rules of evidence that you see in the law shows that are that you see on TV. The policies, as I've been saying as I go along, are not a criminal proceeding. You know, the criminal proceeding is beyond a reasonable doubt, right? Very different sort of case, right? And then you're looking almost like, you know, in a criminal proceeding, you're looking at jail time. So that's why you have such very high standards. Here, you're not looking at jail time, but you are looking at some significant consequences, right, if you're found responsible. But it's a very different proceeding.
Since, maybe you'll get to the penalty phase, but a university or a college doesn't really have a way to impose penalties beyond loss of credits or scholarship or expulsion from the university. Does the prevailing person typically then go to court and say, the school found that I was sexually harassed or whatever? Because there's no teeth in what the court can do, I mean, what the school can do beyond a few scholastic things. But do they usually go to court if the hearing panel is found on your side?
So although the school cannot imprison someone, and the school is not imposing financial, they can withhold a degree and they can expel someone. So that's pretty significant. I mean, I know you know that, right? So that, in terms of, you can probably speak to this too. The experience of going through a criminal proceeding is a, you know, many people choose not to do that even though they may go through with this proceeding. So. And it's also different standards of evidence.
They were not so much as, well, maybe harassed, but if they actually had physical altercation or were forced to do something that they didn't want to do, they usually want to get, I would imagine, if I was aggrieved or if it was my daughter, you know, you'd want to get justice, and that procedure doesn't get you justice unless you actually go to court afterwards. And I guess, simple question, do most of these end up in court afterwards?
I would say most do not. And I also think it's very personal to the student, right? The process of going forward with a complaint is traumatizing, right? It can be very traumatizing. So I wouldn't speak for another person, but I would imagine there are many reasons. Sometimes people just say, I just want to get my education and then move on. There are a whole variety of different reasons, and complainants and respondents decide reasons for going to court and pursuing it. Where I'm seeing most of the cases that I'm talking about here in the litigation, it's either complainants feel like they were not treated fairly within the college context, right? They don't feel like the school followed their procedures, or because they failed to follow them so much that they created an environment that allowed somebody to do what they have alleged to do. Or respondents who feel like schools have not been fair in the way they applied their policies and were discriminatory toward the the respondent, that resulted in, they may say, a selective enforcement case, for example. Whether they choose to go the criminal route, which is a completely different process than what the school process. The school process is not like a civil liability, but it's more like that, right? Where people are, at the end of the day, a judge is saying, you have to pay this amount of money rather than I'm going to put you in court and in jail, right? So,
Should I make a
yeah, please.
comment based on Regent Pope's question? I have two things. One is a victim of a sexual assault can go to the state police, the local police, or the state attorney's office to seek justice in the criminal justice system. But what is the school's obligation if they know about an occurrence and they conclude it's a crime? What is their obligation, if any, to report it?
Supposed to honor the request of the complainant, if that discussion with the complainant, right?
Right.
And then at a certain level, they have to make a decision. They typically have an MOU with the police around reporting obligations.
Right.
May I just add something about that? We are required to share with them how to make a report to the police and how to get a protective order if it's a stalking case or a dating domestic violence case. And some students do engage in that process simultaneous to ours. So I hope that helps.
I would think if someone was a victim of sexual assault, they would go to a police, state police, authority. Harassment, a verbal harassment, maybe not directly there, but yeah, if somebody physically assaulted you, I would think you'd go.
Well, schools have been required to address assault and sexual assault, physical assault and sexual assault, since prior to the guidance, the Dear Colleague letter, and the federal regulations. So this isn't really anything new. Schools are required to address this conduct on our campus. So, I think that's important to keep in mind, and everyone has a different way as to how they want to process that, and so I think that's important too.
Thank you.
And then I think the broader context, and I don't think this is what you're asking, but the school obligation, right? The school is trying to make sure that the campus is a safe place for all students. And so when they're evaluating, for example, the reluctant complainant as well, they have a much broader perspective about if we step away from information that we know, are we posing risk to other students? And that may be another reason why they move forward. Findings, the parties are entitled to written findings, right? And then complainant has to provide remedies designed to restore or preserve equal access to the education program where there's a finding of responsibility. There's nothing in the rules that says this is a consequence that you have, this is a punishment that you have to do, right? That's schools actually put together the range of potential consequences, and they include that in their grievance procedures that we talked about before, but there's nothing mandated within the rule. Again, a school has to follow its grievance process before it imposes any discipline. As I said, the regs don't require certain sanctions. And then we'll talk about appeals. So appeals must be offered to both parties. There's a lot of words on this page, but that's just because there's some specific information that is required in appeals. The rules only provides the baseline for what a school may determine is a basis for an appeal of a finding. Either procedural irregularity, so you didn't follow your grievance procedures and it affected the outcome. There was new evidence that's been discovered that was not available at the time that the investigation and the hearing was happening, and that would have potentially affected the outcome of the matter. Or somebody didn't come forward and admit some bias or conflict of interest, and that affected the outcome. For example, there was a case, and it was decided on other grounds, but during a break, some members of a panel were still being recorded and said some inappropriate things about one of the parties, right? Suggested some significant bias in the process, right? Not great. On the other hand, when we're talking about conflict of interest or bias, an allegation that the Title IX coordinator was a radical feminist, for example, was not a conflict of interest, right? It was just sort of a characterization of somebody that was not supported and that did not fit the bill. Schools have been very good when they're putting their hearing panels together or they're finding their investigators to ask these questions, right? Don't compromise the process. If you've got some conflicts of interest, let us know about them now. And the parties are asked those questions. Or do you believe that anybody involved in this process would have a conflict of interest? Of course, schools can offer additional basis for appeal. Yes, please.
Question on the new evidence not reasonably
Yeah.
available. Does a student or someone have a right to demand that the process restart, or they only have in other words, it's saying the school could have an appeal on that basis, or could a complainant
So the
require
appeals
that?
rest with the parties, and if they came forward and they said there's new evidence that was not reasonably available, they'd have to evaluate what that new evidence is and whether or not it had the potential to impact the claim, and then how they might move forward with that will depend on the circumstances of the issue. They may go back and have another hearing, or they may have limited review.
But is the student entitled to that, or it would be the school's decision?
Well, students only, so the appellate officer will decide whether or not, one, it really is new evidence that was not reasonable, so two things, new evidence that was not reasonable. And then the third thing was whether or not it would have affected the outcome. There's also a lot of litigation out there about whether or not something that somebody said, look, I discovered this about that happened afterwards, and courts have said either yes, you need to address this, or no, we don't believe it would have impacted the outcome of the particular case. So it's going to be a case-by-case process. Sorry, so that's what a lawyer answer. It's a case-by-case process. Once appeal is filed, the school must notify the other party, right, and then treat the parties equitably, including giving them a reasonable opportunity to submit a written statement of their position. The decision maker can't be somebody who was already involved in the process as a decision maker. You have to have a new person involved, right? And the written decision must describe the outcome and the rationale and be distributed to the parties, right, simultaneously. So here's the fun stuff. Record retention, 7 years, right? Good amount of time. And you're retaining everything, right? You're retaining investigation, determinations of responsibility, transcripts, recordings of hearings, sanctions imposed, supportive measures given, appeals, informal resolution, it's all there. For all reports, regardless of whether or not there was a formal complaint, you also have retention requirements, right? So if supportive measures, if there was no complaint filed, what were they? Basis for determination that response was not deliberately indifferent, measures to restore the complainant to the educational opportunity, and if, as I said before, if supportive measures are not offered, a documented reason why, and all of those are retained. And as many of us know in this room, good to do it at the time, because 3 years from now you won't remember why you decided one thing or the other. So good record keeping is pretty important in these cases. Also, you have to post all training materials, but for those who are required to be trained under the regs, and those are your Title IX personnel. Schools have to train Title IX coordinators, investigators, decision makers, and any person who facilitates informal resolution. The training materials may not rely on sex stereotypes and must promote impartial investigations and adjudications. And those materials have to be posted on the website and retained for 7 years. So that's why you may, if you search this, you may see a lot of PowerPoint decks out there. And they may be all very different, right, how people do the training. But it's important that your training is aligned with the regulations, because it's going to be out there, and it's important that you're delivering the proper information to your population and the people who are making the decisions. Interestingly enough, there's not a requirement to train more broadly. There's requirements under other laws, Clery and VAWA, right, to do more trainings, but there's not requirements to do other training. The NCAA does require all student athletes to be trained annually on Title IX sexual violence. Here are the kind of things that investigators have to be trained on: conducting a fair and thorough investigation, determining relevance in order to prepare an investigative report that fairly summarizes the evidence. The hearing officers, they have to be trained on technology so they know what they're doing. Issues of relevance, because again, they're making real-time decisions and presumption that the respondent is not responsible, right, which is a training to do for everybody. Informal resolution facilitators just need to know what the Title IX process is. They especially need to know what the notice provisions are. They just have to make sure that they are in line with everything that's happening. And they also have to make sure that they are adhering to the notice provisions that were put out there, right? What are the rules and how are they playing out? And if somebody says, whoa, stop, I don't want to do this anymore, they have to stop, right? They have to make sure that they know what they're doing in the space. And that, informal resolution is always developing. And then the issues specific to athletics, and I've been talking about athletics throughout the space, and it's not hard to read my resume and know that I do a lot of work in this area, but I also think it's important to talk a little bit about athletics because the NCAA does have a policy on sexual violence, and that policy has been expanding over the years. In the first instance, it required all student athletes to undergo annual training. Some student athletes came forward and said, why do we have this responsibility when other students don't have this responsibility? Is there sort of a thought that we need it more, or there's, right? The group that got together at the NCAA to review this found that many student athletes said that they were placed in situations where they were expected to be leaders, right? And bystander intervention and other things, and we're asking for more training around sexual misconduct policies and processes, so that's part of it. The second thing was to get Title IX coordinators into the athletic space to do the training, hopefully, and sort of make sure that there's communication across campus. Since that time, I alluded to a little bit earlier, there's now a process for screening all of your incoming student athletes, including transfer student athletes, to at least ask if they have been involved in any Title IX processes in the past, right? So athletics is actually held to a much higher standard than we're holding other students to, at least in these respects, and schools are working through those processes. Those of you who are sports fans have likely seen that the transfer portal has had a lot of activity, and there are a lot of student athletes moving from school to school. So when you're thinking about personnel, and if you're thinking you have to vet every single one of these students and their background and determine, in particular for transfer students, whether or not they're transferring, well, they're still under investigation at their prior school, so the investigation has not closed for a Title IX matter. That has required a lot of time, not just in the athletics context, but also your registrar and your other people as well. So this has been taking a considerable amount of time.
So I wanted to kind of give me some color here. So in 2015, I'm focusing on UMBC for a minute to kind of bring it home. All these various activities were occurring by the swimming coach. In November 2020, was it the DOJ began an investigation? And then, of course, the result of that investigation we are all aware of. What I'm trying to understand, okay, we understand that UMBC Title IX office didn't report it. How did DOJ get into this case? That's what I'm interested in. Was it press reports or, yeah, I'm just interested how they got involved and, when the first exchange between DOJ and the school was. I'm trying to get some timeline here.
As a result of another case that the DOJ was already involved in around a different athletics team, in their gathering of all information, they saw an email that sparked a question, and they pulled the thread, and there it was.
So it was the result of another investigation. Was that other investigation, again, not reported by UMBC? In other words, that was, and again, I'm just finding, how did DOJ get into this at all? How did they originally get into that other case, for example?
I don't know the answer to that.
It's just so strange to me that, all these years, there was no reporting by Title IX and just the abject failure of responsibility. But then I'm curious, what's your surmisal here about how DOJ got into this in the first place? How would they even hear about it?
I don't have any information
Have
about
you ever
that,
seen,
but,
have you ever seen a
but-
precedent? Was there other cases like this around? Have you ever seen anything like this before?
Well, there are lots of other cases out there. I mean,
Where
we
the
have-
DOJ comes in
well,
without,
we have the Nassar case, we have a number of
Yes,
other cases
right.
out there, right? So, as I said in the first slide, the Office for Civil Rights can refer cases to the Department of Justice. Department of Justice has the right to come in and do.
No,
as you well know.
yes.
So,
I'm just trying to figure out where, it's not I understand. We can discuss this another time, but I'm just curious to understand the chronology of all this, because, I mean, it really hits to your point about responsibilities and so forth.
and what I would say about athletics, and I also, you know, I was on the hazing prevention board, now called Hazing Network, so I have a lot of experience athletics and other student groups, including fraternities and sororities and other things. I mean, there are hurdles to reporting involved in organizations that I think are things that schools are working very hard to identify and address. You know, in the athletics context, for sure, we're well aware there are all kinds of inherent power differentials. And we do have the added piece of a perception by students that their coaches or others in positions of power have not only their control over their ability to participate in athletics, but their ability to obtain an education because of their athletic scholarship, right? So it's a twofold, right? And we have a long history of discussions in athletics about everything stays within the team, everything stays within the program, right? All the kinds of things I think schools are working very hard, including athletics departments, working very hard to say, that's not where we are anymore, right? This is, and it likely should never have been. Breaking down the barriers between reporting. So, for example, think about when you all were in school. And if, for those of you who might have participated in athletics, you know, how two people who might get into, say, a physical fight, fisticuffs, might be handled when it happens in a locker room as opposed to when it breaks out in a classroom, right? In the classroom context, it would likely go to conduct, likely have all kinds of, you know, in the locker room, it's something that happened in the locker room, and let's deal with it there, right? We're overcoming all kinds of issues. And there are lots of barriers to people reporting in athletics that we are working very hard to address, and I would imagine some of you in this room, myself included, experience those barriers. So it's something that's difficult. Did somebody over here have a question? I thought somebody was moving their mic.
I have, something later, I think, to ask. Well, no, I was only going to comment, Tom, this is more about reporting that circumstance in 2015 up to the Regents, and the responsibility there. And I know we're putting together a standing committee for that, but I was struck, I happened to read the policy on our system's policy on intercollegiate athletics in the packet this particular time. And in that packet, it clearly states the responsibility is there. I mean, it was very, I'm not an attorney, but as I was reading that, it's, you know, there should have been a notice to the chancellor when that happened on that campus. And the idea that it didn't was a real mistake by our president, basically. I don't think it could be any clearer in that policy statement. You can read that and see that. That doesn't have to do with why the DOJ was there, but it has to do with the conversation we had in our last Regents meeting, is that there's a clear policy in place for that reporting to occur. Yeah. And as Heidi just said, as presidents, they all know that. So, yeah,
The other thing I would say, with athletics is, you know, I like the fact that there is required training annually because it is an opportunity to have time with student athletes and to think about all sorts of things, including hazing prevention and other areas that should be addressed, and also overlap with Title IX, right, and are important things. You also have policies and procedures in athletics, team rules and expectations. An important piece is that's all streamlined and doesn't conflict with your Title IX policies and procedures and your other conduct policies and procedures. You know, talking about athletics specifically, but also this also applies to other student organizations. And we also see challenges around club sport participation, right, as well as intercollegiate athletics participation. Yep.
Can I, and this is not a question directed at you, and I'm not sure which this should be, but my question was, throughout your presentation, there were numerous places where you said the language could be tightened up in our policy, and in the case of the standards that there are two different standards that we could use for the preponderance of the evidence and those kinds of things. So my question is really more directed, I don't know if it's at our council or if it's at the chancellor's level, but is our policy on Title IX uniform across our universities? And so is it the same, or do each of the universities have their separate and have the ability to have their separate language and make those decisions separately? And then if so, are those policies all, I guess they're being reviewed and have been reviewed, but it seems to be I'm not going to say, well, I'll say it, there may be landmines in that whole, process. So it's pretty important.
Let me be very clear. This training today is about the Title IX regulations. So where I say schools can do more, I'm not referencing your policies or procedures. I'm just talking about what the Title IX regulations are. Some schools have different policies at different institutions because of the makeup of the school and because the policy works differently around grievance procedures. That's not to say that's a good thing or a bad thing. Some systems have the same policy and then they have specific additional things that may happen. Some have different policies. I think those are all sorts of things that you're all going to be thinking about. But on top of that, there's legal compliance, and then there's best practices, and that's a different. You can have two different policies that are both best practices for that particular institution.
Well, and I was thinking about, where you have to have a Title IX coordinator, but then you're talking about having investigators, and we have such a diversity of universities, and the size of those universities and the resources that those universities have are completely different. In our flagship, it's probably much, I'm not going to say easier, but, they have much more of that.
Angela's here, so I was going to ask her, she's the flagship.
Yeah, but
so
I mean,
was
at
gonna
our
ask
smaller,
her to weigh
smaller
in.
universities, they don't have that. Yeah, they don't have those type of resources, so it's a real challenge.
Yeah.
And therein lies the conundrum. Yes.
So Angela, you want to weigh in there?
Well, I think what's nice about being here is we can talk about options for maybe making that easier at some of the smaller schools. Many systems do have a system-wide, maybe a coordinator in place that can help with other schools that might not have the same resources that we fortunately do at College Park. And so sometimes systems will share investigators or share hearing officers, share appellate officers, and that's certainly something we'll talk about.
Yeah, okay.
Angela, which school are you with?
I'm at College Park.
College Park, okay. Maybe you said that.
And I just want to add one more thing. A lot of the students that actually make reports are not seeking to have a formal. It's a lot to engage in a process such as this. And if you experience something, you probably wouldn't want to tell an administrator or hearing officer and everyone else, and that is someone's right. But I just want to clarify, a lot of what we do is providing supportive measures or directing people to resources, or students, their educational experience has been impacted. So they're really just seeking that support and help, and we're directing them to resources. And so it is, everyone has their own, experience and how they want to handle things, and it's very different sometimes. And we also have to have a very fair and balanced process and ensure that we're supporting all students through that process, and objective in how we review it, and following our rules, so that, if there's not a finding of a violation, not evidence to support that, we're helping the students move beyond that after. So
I don't want to lose sight of the issue you just brought up about resources, though, because no matter what size institution, this is very human resource intensive. So it's very challenging for all of our institutions. And what you heard at the very beginning is that we have new rules and regulations coming down the pipeline, and we have no idea what that will mean in terms of resources that will be required, where often there are no funds that go along with this. It is, you might get training through VAWA, Violence Against Women, that grant, but there are a lot of uncertainties around human resources, so it's a demanding, it puts a strain on all of our institutions.
Yes. I would follow up with that and say I agree with President Burrow. It's very, very labor intensive. Just having investigators work with the students, having a shared sources at the system level, that would be very, very helpful. And I'm hoping that this work group comes out with some of those type of recommendations. The other question that you asked about the policies and rules, we all have to follow, obviously, what the Department of Education has laid out, but we may put extra things in. So, for example, at our very small institution, bullying has become a very, very big concern that we have to focus on, we have to investigate. So we have now tied our bullying to the Title IX office, and you can imagine that has become very, very big with students reporting that, with employees reporting it, and that's become even more labor intensive. So that's one example of how our policy probably is very different than College Park or than Bowie. We have some other little things in our policy that's different, but the basis for sexual harassment, that is all the same for all of us.
Yeah, what I take away from this is what we've heard today from Janet is, here's what you got to get done. These are the rules no matter who you are and what kind of an institution you are. So our challenge is going to be recognizing that there are differences in resources. Those are the rules, and we've got to figure out how to comply with them.
Yeah, and so Hugh, these are the federal regulations that we all must adhere to, and how we implement is the next phase.
Yeah.
And
Janet, in your earlier comment, you said a red zone. What exactly do you define as a red zone? Is it is it the first 90 days of the semester or something? And secondly, what's the percentage of incidents that occur in that red zone? I'm just curious to look at that.
So different people define it differently. It's typically, August through Thanksgiving. Some people take it further, and it's typically, research has shown more than 50% of your sexual assaults are happening. More than 50%.
that's a lot. Dave, you had your hand up?
Yeah, from your perspective, where do you see organizations falling short? Some of the more common areas you see organizations falling short in Title IX, and what might be some of the root causes for those shortcomings?
Staffing. I mean, if you hear anything from this, imagine taking this on, right? And
Just which is
and in order to live up to your expectations, you have time frames happening in every single one of these cases, and record keeping that I showed, and and you've been through this. You see how demanding the expectations are, and rightfully so. Students have those expectations, right? This is, why is it taking so long to get back to me? Why are we doing this? And then the people skills that are involved in this are special skills, but it's high burnout work. So you have all of that happening all at the same time. And then you have people come, it's human nature. People come in and say, you have, 4 people. What are you all doing? Well, now you've been through this for 2 hours. Now you know what people are doing. And I would echo, the vast majority of it is at the front end, the supportive services, and coordinating all of that and making sure that they're getting, and, I will only speak for myself as a mother, finding them and making sure that they did everything and responded to, and the fact that I have to send them a picture of my black Labrador retriever to get a response from a text message, you can only imagine what the broader context of trying to make sure all these pieces in place and all the people who are doing all these things are keeping those people who need some very real things, who may be experiencing trauma, in the loop and that we're not losing them. So I think on the front end, putting together those policies that not only comply with the law, but are workable, right? That your people can use and that people are going to trust, and you're engaging with the people who are actually doing the work, not imposing it on them, is incredibly important. So it's time-consuming work, but it's well worth the work. And then it's resources is the second piece, right? It's just, are you continuing to invest in this? It's a very important area. Let me just finish it up for you. So then this is my last slide, I think. Retaliation is prohibited. So, it's a very broad-based anti-retaliation provision. People who bring complaints, people who participate in the proceedings, right, have the right to be protected from retaliation. I think, training people that they say this all the time, saying it and having somebody believe it are two different things. So I think we've just done full circle for, how come people didn't report these things year after year. There is a real fear of retaliation without anybody saying, if you say something, I will do something. So retaliation is very real. And so, that's a separate and independent claim that somebody could bring under Title IX, as well as a claim that they've been treated so disparately in the process on the basis of sex that they also have a Title IX complaint there, right? So those are additional sex discrimination. You have been, we're at 5:56. I think we're going to 6 o'clock. I'm quite proud of myself right now. Amazing questions and engagement, and I certainly will be here for a little bit if anybody wants to speak publicly, but thank you so very much for inviting me here today. I'm sorry, there's another question.
Can I ask one quick question?
Yes, please.
Janice, first of all, thank you very much for a great presentation. Can you give us any highlights of, I know the rule is not going to drop until tomorrow or the next day or whenever, but can you give us any high-level highlights about what we can be expecting? The one thing I keep hearing is they're not going to be as prescriptive, which I'm breathe a sigh of relief. But what are the bigger highlights? Can you give us any of those tidbits?
It depends on how you define prescriptive, right? Such a lawyer. One thing that, if I were a president of an institution and I was thinking about my budget, broad-based training is likely, absolutely, and that costs money, right? And time and effort and engagement of people who already believe they are overtrained and have to be involved in, it's just another thing. And students who are already so busy and part of it. I think it will broaden the responsibility to report, so you're going to have to make some decisions around that. We'll see, but likely could be the investigator model, right? So we'll see what happens there. But, this, I'm just jawing with you here because, many comments went in that were quite thoughtful. The other thing is a much broader definition of sexual misconduct that includes, right, gender identity and other things. To your earlier comment, the trans athlete regs are not coming out, and I don't believe they will be in any way, shape, or form incorporated into this. So that's a separate piece. And also, if I were, much more detail around pregnancy and parenting, that will require lots of thought and training and additional information there. So lots of things. I think we'll see about the cross-examination piece.
Thanks for doing that.
Sure thing.
Any other questions for Janet? Janet, thank you very much. As you can see, with this one aspect of Title IX, we spent 2 hours. And Title IX is so much more comprehensive than the one aspect that we're focused on right now. And so thank you for distilling that aspect down to something that we could get our heads around. And thank you for spending the evening with us. Appreciate it.
Again, I'm just impressed with the questions and the discussion, so thank you for having me here. So thank you very much for being there. Appreciate you.
Do you want to make an announcement about dinner?
Yes, I think people might be thinking about that around this time. First of all, welcome to Bowie State University. To those of you I didn't greet